Welcome everyone. It's a pleasure to have you here. We will talk about a financial hot topic right now, which is called DORA. So I guess most of you are already familiar with this upcoming regulation. We are approximately 4 months before its effectiveness. So we still all have a bit of time, even though there's a lot of work to do. So the idea today is to have a broad overview of what DORA is, to whom, to which entities it's dedicated for, but also to have a lot of practical tools that you might, and we hope you will find useful for your own implementation of this regulation if you are subject to it. So to dive into the subject, what's DORA about? Basically, it has been designed to enforce the inability, it's written in the regulation itself, the inability of the European financial services to continue to operate in the event of disruption of the services. So the statement was that there's a weakness in the financial sector in Europe when it comes to cyber security, and the idea of DORA is to force the operators to improve their knowledge and the process. So what do we mean by disruption? Well, it's very large. It includes hacking, data loss, technical failure, contractual dispute, power cut, destruction of equipment, natural disaster, etc., etc. So many companies that are already subject to the CSSF superview are already quite familiar with those obligation, disruption teams, and have already in place a lot of things that are covered by DORA. And what we will do today is to try to show what are the differences and where there should be improvement, even though you are already subject to the notably the 22806 circular of the CSSF. What's the goal for DORA? The idea is simple. Europe, as every country in the world, is facing a lot of digitalization needs, but also is facing a monopoly of certain players and a dependence on certain subcontractors. By this, of course, the idea was also to protect and to develop European technology against US technology, the GAFAM, etc., etc. So, which entity are subject to DORA? Here you have the broad list that is included in the regulation itself. So, as you can see, it covers most of the financial sector entities. Of course, in Luxembourg, when you are supervised by the CSSF, you will most likely fall under the DORA regulation. Even though there are certain exemptions, the first step will be to assess whether you are or you are not under the perimeter of the DORA regulation. So I will not go through this list. We will share the slides after this training, so you will have all the information in it. There is also the third-party ICT service providers. Here we are talking about Article 3 or 19 of the DORA regulation, and it includes cloud computing services, software developers, and data analytics services and providers of data center services. So it does not only include service providers or bank and supervised company, but it's more large. And again, the first step is to assess the impact of DORA on your activity. It also includes intra-group service provider. This is always This is always a discussion whether you fall under the regulation where you're dealing only intra-group services. Here it made clear that it's in the scope. There are some exemptions. You will see the complete list on the 2 next slides. In Luxembourg, probably the AIFM ManCos might fall under those exceptions. So when there are less of 100 million assets under management, and when there are less of 500 million assets under management, in case portfolio are made up of non-leveraged IFS, for which no redemption rights may be exercised for a period of 5 years. So this is mainly the same definition as usual. Those ManCos will not fall under the DORA regulation. You will see in the slides that there are other exemptions. We don't think in Luxembourg this will apply a lot, but again, this is part of the assessment. So retirement provision institution, natural person, insurance intermediaries, payment institution, but if their payment transaction is lower than 3 million, which means probably no one, or electronic money in circulation lower than 5 million. So same statement. And insurance and reassurance companies, but with very low threshold. So we think this will not apply, at least in Luxembourg. So what's DORA about? Still another point of view. The first point is that DORA implements a kind of, well, not a kind, a proportionality in its obligation towards the targets, which means depending on the size, the risk, the nature, the complexity of the services, etc., there will be values, there will be several different levels of implementation that will be required. And you can fall under Article 16, Simplified ICT Risk Management Framework. So once you have decided, once you have assessed whether you are in that or not under the DORA regulation, then you can, the next step is to check which is the framework you will fall in. There are 3 levels of requirement you will have to check. The first one is, of course, the DORA itself, the DORA regulation. But then there is a second step, and Laurent will explain this more in detail. But the second step is regulatory technical standard and implementing technical standard through a directive, a European directive. And the third step is national measures. The amendment to the law have been voted and will be effective the same date as DORA on the 17th January 25. In DORA, you will see 6 pillars, and on this, Laurent will explain a bit more. General provision, ICT risk management, related incident management, digital operational resilient testing, managing ICT third party with key contractual provisions, and information sharing arrangement.
Thank you, Renaud. Hello, everyone. So to expand a bit on what was just said on the base level, the base level 1, we actually have 6 content topics in DORA. The first chapter should really be seen as 2 topics, with the first one covering internal governance. So in a nutshell, the ultimate responsibility of your management body on the digital operational resilience of the financial entity. So not only your authorized management, but also the supervisory body of the institution, like the board of directors. And then the rest of the chapter is on the ICT risk management, and I'll come back to that, and to the other 2 topics on the left hand side of the diagram, which are the ones which are not fully applicable today. On the right-hand side, ICT incident management, classification and reporting, the CSSF actually took the option to implement those requirements in advance of the regulation. They published a while back, beginning of the year, circular CSSF 24847, which effectively implements either 1st of April or 1st of June, depending on the type of entity, those IT incident management requirements in advance of the key date of 17th January 2025. Last but not least, bottom right, information sharing arrangements. Here it's optional requirements with an objective for the legislator to encourage those information sharing practices and to make sure that there are no legal obstacles to exchange cyber threat information among trusted participants. So to deep dive a bit more on what remains to come into application, the ICT risk management and related chapters. As you can see here, the expectation is to have a duly documented, regularly updated set of documents to describe the ICT risk management framework of the financial entity. So this can be policies, procedures, protocols, tools, etc. To make sure that the objectives of the regulation are fulfilled. There should be also the involvement of an internal control function, so effectively requiring to deploy the 3 lines of defense model on the topic of DORA, with first line of defense, basically the operational teams like the IT department, the security operational teams, could be part of the IT department, could be a separate team. Then an internal control function, like compliance, like maybe more likely risk management, embedding this ICT risk topic into the broader operational risk management arrangements. And last but not least, third line of defense, the internal audit function, looking from time to time based on its risk analysis at all this setup. One key element also as part of all these ICT risk management chapters are the digital operational resilience strategy, which is pretty much a policy type of document outlining how the financial entity is addressing the regulation, and it should be clearly the key document to be validated by the management body in order to show that the internal governance arrangements have validated the setup. So we, compared to the existing requirements for the majority of you in circular CSSF 2750, DORA goes a bit more into detail on the expectations of how the risk management should work, from the identification of risk to their assessment, to their treatment, the lessons learned, and really having good leading practices on operational risk management is important to well support and facilitate demonstrating compliance with this regulation. So on the following slide, I have the 2 other chapters, which are really integral components of the one we just saw, the ICT risk management framework requirements. So firstly, the digital operational resilience testing is actually twofold. There is firstly this testing program concept, which calls actually to do some key controls testing as part of the operational risk management, because if you just do a theoretical, let's say, risk assessment where you take your risk, identify your controls, and conclude on the residual risk, you don't have information on how well the controls are implemented. You don't have information on how well the controls are operating effectively. And that's really, let's say, the reality check part of the risk management to make sure that the key controls, the ones which are most relevant, this can be a risk-based approach, are properly implemented, properly operating effectively, and well aligned with and underpin support the conclusions which have been taken on the residual risk which have been assessed. Second topic in this digital operational resilience testing is a legislative upgrade of a program which has been around for a couple of years and which applied to the larger banks in the region, a program from the European Central Bank called TIBER, which is about sophisticated penetration testing to stress test the cyber security measures of a financial institution. So the baseline frequency for this is every 3 years. National competent authorities have the flexibility to adjust this frequency, and this, you have to realize that this is really a time-consuming endeavor. It goes well beyond red teaming exercise, adversarial simulations that some of you may be familiar with, because it's a multi-partite exercise with the involvement of the competent authorities. And let's be realistic, this will not apply to all the financial institutions, and we can expect it to focus more on the institutions which have a market effect and which are important for the global stability of the financial sector. Okay, so obviously Renaud mentioned initially that we've seen a lot more reliance on third parties for the past few years in the financial sector with the advance of cloud computing and so on and so forth. So ICT risk party management is a very important part, a very important extension of the risk management aspect. And here the key message to process is that the scope is going well beyond the scope of Circular 22/806, well beyond the scope of outsourced service providers like we've known them for the past few years. It's covering comprehensively all ICT third parties, and I'll provide examples on the next slide. So what is also important to realize in terms of philosophy of the regulation is that, like Renaud mentioned, the ICT third parties are in scope of the regulation, and the reason behind that being that the European supervisory authorities, like European Bank Authority, European Securities Markets Authority, gain a new power to designate among those ICT third parties serving the financial sector some critical ICT third parties, which will be subject to oversight of the European supervisory authorities. And to determine which ICT third parties are critical, the European supervisory authorities are looking at collecting a lot of factual information on what is the usage of ICT third parties by financial institutions in the region, what is the magnitude of the services in terms of fees, for example, does it relate to key functions of those financial institutions or to less important functions. And we have this new concept of register of information. So for those of you who have already worked with a register of outsourcing arrangements, you probably remember some headaches about that. The register of information, I'm sorry, it's worse because there are a lot more data points and it's a lot more iterative in nature. Whereas in an outsourcing arrangement, you could have maybe just one record for a third party. In the register of information, because the European supervisory authorities are looking at understanding the magnitude, the level of reliance that the financial institution has on the third party, it's going to be more than one line, more than one record for each third party to reflect precisely what it is used for by the entity. So if you're providing some operational services for a market room in a leading European bank, it's not the same as software as a service for HR processes in a small investment firm in another member state. Also, in connection to the third-party risk management, there is this legislative upgrade of what we had in Circular 22/806 on internal documentation, due diligence about the use of third parties with the concept of risk assessment, due diligence on the service providers, conflict of interest assessment, making sure that supervisory conditions are met if it's a thing for the type of services being provided. And last but not least, making sure that the contractual arrangement satisfies a number of requirements. So I think that this has been historically a topic which could lead to difficult conversations with service providers, and now there is more power in the legislation to make sure that the contracts fulfill the specific needs of financial sector entities. So before going back to Renaud, to give you an illustration of how the scope of Circular 22/806 and the scope of the ICT third parties under DORA and the Register of Information differ. Here you have an excerpt of the implementing technical standards on the Register of Information, and specifically the Annex 3, which outlines the 19 different types of ICT third-party services which should be included in the Register of Information. And I will not go over the list, obviously, but you have some non-surprise topics like run services, cloud, etc. But what is more surprising is, for example, the second one on the left, ICT development. So if you are using a third party to do third-party maintenance on an application, to develop a new component of your information systems, this would have to be declared. And on the right columns, things which can be surprising probably for you is the fourth one, software licensing. So just the mere fact of procuring a software license from a software publisher would need to be declared. And ICT consulting, so I will end up also in this Register of Information for some of you in the market, which can be surprising. Well, I don't expect to be designated critical ICT third party yet, but you can see the scope is radically different from the scope of Circular 22/806. Brief word about this three-level structure that Renaud introduced. We obviously have the level 1 text, which are the main regulation on the top left, technical directive aside to the regulation whose objective was just to allow the member states to update their national law coming from European directive that needed to recognize DORA regulation, and also set the enforcement powers. And here, as Renaud mentioned, the law of July 2019, which operationalizes European legislations for the financial sector, has been already voted, updated in July. And for DORA, the administrative fines which are foreseen are actually not different from the other ones applying to other European legislation regulations. There is up to 5 million euro administrative fine possible for physical persons. That could be members of the management body or people who are directly responsible for breach of DORA, and up to an amount of maximum 5 million euro or 10% of the annual total turnover, so whichever is the greater, for legal persons like the financial institution. On the second and third line of the slide, you have the level 2 text. So, as Renaud mentioned, the European supervisory authorities have been empowered by the Commission, by the main regulation, to develop some regulatory technical standards and implementing technical standards. And on the second line, you have those which will apply to financial entities, which should be probably the priority for most in the attendance. And on the third lines, the texts which are related to the oversight, the designation of critical third parties. And in the color code, you can see those which are already finalized in dark green. Those texts which have already been published by the Commission as Commission delegated regulation. So effectively, it has the same power, the same level as a piece of legislation like the main regulation. And in light green, the ones which have been finalized by the European supervisory authorities, which have been through the consultative process, but which have yet to be vouched by the Commission and published as Commission delegated regulations. And as I mentioned, the contractual aspects are an important part of DORA, and I will hand back to Renaud at this point.
So, as Laurent mentioned, there's a lot to do. We are D-Day less 4 months, so many things on the table. Amongst those things to do are the review of the contractual arrangement with third parties. This was already a topic with Circular 22/806. It was a hard topic actually because the timeline was relatively short, and for many companies it was very hard to implement on due time. It happens that we are still working on this, so the idea would be for every company falling under the DORA scope to implement both together, and for those who have already implemented the circular, to update existing agreements. So first step on the agreements themselves will be to assess whether the third party falls under the DORA regulation, and if you have to update the existing arrangements. So which are the arrangements that should be checked first? Of course, when you fall under the DORA regulation, you will have to give a broad description of the ICT services to be provided, specific clauses on confidentiality, integrity, availability, access, recovery, return of data, assistance in case of incident, cooperation with authorities, and termination of rights. There are specific additional clauses to be foreseen for critical and important functions. So there is, of course, it was equivalent in the circular, but SLA, service level agreements, notice period and reporting obligation for the development of new services. This will also be in the register, as Laurent explained. You will have to implement or to assess in the agreement the way of implementation of required documentation, so business contingency plans, ICT security measures, security policies, audit rights, and monitoring of performance and exit strategy. So you will have to check all this, which means a due diligence period and a risk analysis first. A short point on critical and important functions. You will see that the definition in the circular and the definition in DORA are slightly different, but slightly different makes a different analysis, and you will have to not only to rely on the assessment you did for the circular, but you will have to reassess the third-party providers. As you can see in the DORA, the main point described are the disruption of services that are essential to the real economy or disrupt financial stability. So it's in the recital 70. And the definition is in Article 3.22 of DORA. Function that materially impair the financial performance of a financial entity, soundness or continuity of the services and activities, impair the continuing compliance of a financial entity. It's covered in the circular, but the circular also talks about internal control, key banking services, payment functions that are outsourced. So the scope is broader in the circular. This means you will have to assess whether you will have to report in your internal documentation or not, and if you will have to upgrade the existing agreement. So again, there is a big due diligence work to do on the scope of what you have to do and what is not necessary. We wanted to make a point with regard to close existing regulation, which are the GDPR, the Data Protection Regulation, and NIS 2. So the scope GDPR is in force since 2018 already. It covers personal data, but it's transverse, which means all the companies, including the one falling under the scope of DORA and the one falling under the scope of NIS2, have to apply the GDPR rules with certain topics that are really transverse, such as the registry. You will have to get a registry under the GDPR, under DORA, but also under NIS2. So these are transverse topics, and you will have to think about the team that will work on those different elements, whether they should be separated or not. Of course, our recommendation is always to keep it as close as possible from the legal team to the technical team, because again, those topics are very transverse. NIS2, shall be transposed in every national state by the 18th of October, so it's very close. In Luxembourg, this will apply, same as for DORA, you will have to assess whether your company falls under this, but when it comes to the financial sector, in principle, you do not fall under NIS2 regulation. Maybe except support PSF falling under Article 29.3 of the banking law. So for those companies, they have to make a specific assessment because they might fall under NIS2 regulation. So the topic of DORA is management and recovery from ICT incident. Needs to improve cybersecurity and incident response capability. And here on this slide, you have the relevant authority for each of those regulations in Luxembourg. So the CNPD, ESMA, which is at the European level, ABA, and the European Insurance and Occupation Pension Authority for the insurance. For NIS2, this will be the circle, which is well known from all the cybersec people, because this is an extremely powerful and efficient service that is granted for free, unless mistaken, always for free, by the state to the companies. Here are table of the documentation and formalities. So we will not go through in detail. You will again get the slides, but the topic, as you can see, are many of them are crossing the different regulations. So information security, incident, third-party management, asset management, with every time a different type of documentation that is required. So while drafting those documentation, you have to be careful not to put information that would be different or worst case that would be opposite one to the other. And also recovery and backup, which are under DORA and NIS2, but not under the GDPR. This is maybe the good news. So a key point while assessing, implementing the DORA regulation will be to take into consideration the overlapping with the other regulations, such notably the GDPR, in terms of risk management, incident reporting, technical measures, third-party management. Again, while you're still involved in those projects, we'll have to complete a lot of internal documentation. So you have to be very careful about the continuity and the compliance of each information put in the relevant documentation to avoid contradictory information that would be granted, one to the CNPD, the other to the DORA regulator, depending on where you are and which authority shall supervise your company. And then I will let the floor to Laurent.
Yeah, thank you, Renaud. So the CSSF has invested a lot of time for the past months to mobilize the market. They published a lot. They updated the website. They participated to many conferences, and they articulated some advice. And I think it's very good advice. So I share it here with you if you haven't seen it already. So first advice of the CSSF is to create a DORA task force. And as you can infer from what we presented so far, DORA is really a transversal topic, touching internal governance requirements of the financial sector, touching operational risk management, touching IT security, information technology. And you really need a transversal team as well to perform your gap analysis. Otherwise, you might have some bias in the gap analysis you are performing. So the expectation of the CSSF is that entities mid-January have a properly documented gap analysis on where they stand towards DORA compliance, and a defined, documented, and priority-based action plan and implementation timeline to eventually become compliant. So you can deduct from this that not everyone will be compliant on 17th of January 2025, but what is super important is to be able to really show how far you are and what is the journey to get there eventually, and that this journey is credible and also risk-based, so that it makes sense and starts by what is more critical, such as the critical or important functions. Well, they also invited to leverage on peers, professional associations, etc. And going back to the slide where I was showing the texts which are fully finalized in dark green, the ones which have yet to be published by the Commission in light green, the advice of the CSF for some time now has been not to wait for the final text and to work on the basis of the final draft. So please feel free to have a look at these if you haven't had the chance yet. Second point is around having a proper comprehensive mapping of the different business functions of your financial institution with the supporting ICT functions and assets. So in order to achieve this ultimate objective of resiliency, digital operational resiliency of financial institutions, you really need to know what you are trying to maintain resiliency for. Otherwise, you're going to miss the target or the priorities. And here, typically, financial institutions which have invested in their business continuity management arrangements will have a high return on investment for those efforts, because it will, as the typical documentation element that already exists, which might significantly reduce the efforts to do this mapping of business functions with supporting ICT functions and assets. As we already mentioned, the Register of Information of Relationship with ICT third parties is really a new dimension compared to the existing outsourcing registers, and the time it will take to fill this out should not be underestimated. Also, what you have to realize is that the CSSF has already indicated they will ask for this in the course of February 2025, and the information will not stay in Luxembourg. It will go one level up to the European supervisory authorities, who have to do their secret processing of this data to determine who are the critical ICT third parties. So this will be data which will be looked at by more than one regulatory body, and you should really not miss this part of the DORA compliance endeavor. Last but not least, the CSSF has advised to, in priority, establish the policy on the use of ICT services provided by third parties. And in connection to that, we have the contracts with those third parties. So the expectation is that new contracts that will be entered into as from 17th January 2025 should be already compliant with the requirements of DORA, and that for the existing stock, for the legacy contractual arrangements, you also have a plan in order to prioritize how you will progressively remediate those contracts and ensure they are compliant with DORA regulation. So DORA is not a one-off. This is a journey. The expectation is to adapt your processes and have these continual improvement loops in order to make sure that the digital operational resilience level is satisfactory, maintained, and potentially improved over time. So yet again, the core objective is the operational resilience, which implies that you need to have a good understanding of your ICT systems and also a good understanding of the related value chain. So what is internal, what is provided by third parties, who are the most critical third parties, etc., etc. As we mentioned before, the incident reporting requirements of DORA are already very largely applicable in Luxembourg, either 1st April or 1st June through Circular CSSF 24/847. And on this, you might have to deal with cultural change internally, because sometimes it's very difficult for management or for key function holders to declare an incident to the CSSF. But you know, CSSF, they have had such reporting obligations for payment services for a number of years already. And so they are not only looking at each financial institution individually, they are also doing so-called horizontal supervision, and they are comparing data points between the respective institutions. And honestly, I think it's better to report some of your major operational ICT-related incidents or security incidents than reporting zero. You don't want to be an institution which reports zero major operational ICT incidents or security incidents. It's rather this kind of under-reporting would suggest that you probably have a lack of detective controls on security. Timeline again, number 4. So in early 2025, the key elements which will be required will be the ability to provide your situation, your progress on an action plan, and what is the timeline to eventually reach the level of compliance that you and your management body feel comfortable with, following the principle of proportionality. And in the course of February, the Register of Information, whose detailed format is defined in the implementing technical standard. Last but not least, DORA is a collection of texts. They are very much detailed, and sometimes it's useful to go back to the existing regulation, to Circular CSSF 2750, to kind of get your head out of the water and to try to focus on some of the requirements which matter most. I think this circular will remain applicable for those institutions who are not in scope of DORA, and will remain useful for all financial institutions in the coming months.
So to conclude with just a short word, at DSM and at Derisk, we are advising many clients on this topic. We always try to have a very operational and pragmatical approach on what we can offer and the way we will assist our clients. So feel free to contact any of us for the different requirements that you would have about this topic. Thank you for assisting. So there are 2 questions. Maybe I will take the first one.
Sure.
So the first one, I don't know if people can see it on the screen.
Yeah, everyone can see it, but we can also read it for the people that are watching maybe the replay after.
So what is your opinion on the board of directors' responsibilities, AIFM, ManCo, and fund regarding DORA? What will be the impact and where should the directors focus on in terms of DORA and its preparation and execution? Any recommendation? So maybe the first point about the responsibility or the liability. DORA is a regulation that is about the entities themselves, not about the directors, I mean, as individuals, but the entities are of course, managed by the board of directors. So on first line, it's the entity which has to be compliant. And there is no specific liability for the directors themselves, unless in terms of general liability under the commercial law and in terms of, I would say, authorization by the CSF when it's needed. Of course, in case there are fines or sanctions of any time due to the lack of implementation of DORA, that might also impact them personally regarding their authorization. Besides this, it focuses on the entity themselves. So what will be the impact and where should the director focus on in terms of DORA? I think this is what Laurent just explained. There are a couple of recommendations, and I would say see maybe the last slides of the presentation, and you will get a very, at least a first way of important things and how to deal with them.
Maybe to complement what you said, and which I agree with, well, there are no hard requirements today in the suitability assessment of board members on those technology, digital aspects, but clearly in the regulation there is detailed requirements to train the members of the management body. So depending on the level of comfort with those topics, I think that's the starting point to make sure that they are comfortable in entering into more value-added conversations with the operational teams and management on this. Well, one potentially good practice is to designate one of the members of the board as the champion for those digital topics based on his or her knowledge in order to have clearer ownership, accountability on this specific topic within the management body.
So there is another question, maybe, yes. How the ICT service provider will be able to demonstrate the highest info security standards in improving services to financial entities per Article 28.5 of DORA? Would the ISO certificate 27122 be sufficient?
Yeah. So this sub-article, it basically, so as part of the ICT third-party risk management, it basically requires financial entities to only enter into contractual agreements with ICT third-party service providers that comply with appropriate information security standards. Actually, there is no keyword which implies that this necessarily requires a certification or an audit report from the ICT third-party provider. So I think there is some flexibility on how the service provider may demonstrate this to the financial entity, and it will also depend a lot of the peculiar due diligence process the financial entity applies to the service provider vis-à-vis the criticality of the service we are discussing. One of the leading practices is to tier your service providers into more than 2 levels in order to prioritize the due diligence efforts on the providers which matter most. And the question mentioned also about potentially showing an ISO certificate. Yes, that would be having an ISMS and having this ISMS certified would be a great step and potentially would help you reduce the amount of time you have to allocate to the due diligence of this prospect or of this existing client.
And the last question is about the timeline for the publication of ESA list. Well, unless mistaken, we don't know yet. I invite you to follow our DSM LinkedIn profile because we publish regularly information on those things. So very short communication. So you'll get the information, but maybe Laurent, you have more insight than I have.
It's not finalized. There are still some discussions ongoing from what we heard, and for sure they require to receive the source of information to work on this designation in February of 2025. So I think it's clear it will take a couple of months before they can announce anything. There will be also probably some consultations with the national competent authorities in the different member states to make sure that these designations make sense vis-à-vis the financial institutions which are directly supervised nationally. So I think at best the designation will come in the summer of 2025.
So thank you very much.
Okay, thank you so much for participating, and we wish you a very nice afternoon. And
don't hesitate to contact us if needed. Enjoy the rest of the day. Bye.
Bye-bye.
Thanks for making it. Thanks for the questions.